Is that problematic? You betcha. Does that require some re-articulation of certain aspects of the Constitution? The answer is yes. But in terms of weighing the good and the bad, the cost-benefit, I would suggest that that is a workable solution, and let me tell you how it works. In my former life, when I was in the IDF, I was a judge in administrative detention hearings. For those of you who are unacquainted with administrative detention hearings, administrative detainees are Palestinians who are detained based on sources that suggest future action when the source can't be outed. Because if the source is outed, he'll be killed. And so as a judge, I would review intelligence information. I would wear two hats. I have no hair, but I would wear two hats. One is that I would be a judge. I would review the information. And two, I would play the role of the defense attorney. And my primary emphasis was to convince the intelligence community, intelligence services, to declassify the classified information in order to enable confrontation of the accuser. The second thing was, this was a primary responsibility, was to determine the reliability and the viability of the source. Because if the source is deemed by the judge not to be reliable, then I would suggest the intelligence information is not admissible. So in the context of creating domestic terror courts, the judge will wear two hats. He will review the classified information. All other evidence will be subject to the right to confront the accuser. There will be no jury trial in my proposal because I think for a number of reasons. One, I think bringing thousands upon thousands of detainees before jury trials, there is a sense of impracticality to it. It will simply delay the process, and we need to get a process going. There are thousands of people, keep in mind. And the second reason I would suggest that jury intimidation would be a significant factor in the trial of terrorists. The second part of the proposal is, what do we do if the person is convicted? Because my proposal is predicated on a civilian process to demilitarize it, with all due respect to all of you in uniform, the appeal will be to the United States Court of Appeals, and if need be, to the United States Supreme Court. So what it suggests is a demilitarization of the process, ending the military commissions, bring somebody to domestic trial with the possible exception of having classified information introduced. What would conviction be based on? Well, in the ideal world, the conviction will be predicated only on the criminal evidence where there's the right to confront. But in those cases where the criminal evidence is insufficient and there's a need for the introduction of classified information, the classified information can only serve to bolster the criminal evidence, meaning the following. The classified information in no way, shape, or form can be the sole basis of conviction. It can be used only to bolster. I've been repeatedly asked when I make this presentation, what does the word bolster mean? Bolster means bolster. Does bolster mean 25%, 32%, 47%? My very honest and candid answer is I'm not sure. It's one of the issues that obviously requires thinking through, because how far do you go with the word bolster? But the majority of the cause for conviction will be the criminal evidence and not the classified information. With respect to who will represent the detainee, the defendant, it will be a lawyer of his choice who will be present throughout the hearings, with that one exception. Working my way backwards, once we bring somebody to trial is almost the easy part. How have we brought him to trial? What has been the interrogation regime to which he has been subjected? I wrote a book that, as I understand, is available for sale here. You love plugging your own books, called Constitutional Limits for Uncoercive Interrogation. When I wrote the book, and Mary Ellen, I look at you, I was flooded with emails from interrogators in Afghanistan who somehow, I have no idea how, found out that I was working on this book. And as if asked me to be their voice in the following way. Because one of the realities of the interrogation process that was established in the immediate aftermath of 2001 is that it was, in essence, lawless. It was without written authorizations, and those written authorizations that were in place were highly problematic, if not illegal. In the context of establishing a domestic terror court, precisely because I recommend the introduction of classified information, there can be and there must be no torture whatsoever. But deeper than that and more profound than that, how somebody will be interrogated will be subject only to written authorization by the head of the intelligence service, meaning that there will be full responsibility and accountability. there will be no more hiding behind this, call it this amorphousness or this nod and a wink. More than that, the detainee who will be subject to this domestic terror court will be given his Miranda rights. Play it out. Let's say, for instance, hypothetically, that Osama bin Laden is captured today in Afghanistan, Pakistan, or wherever he is. Probably not in Topeka, but wherever the hell he is. In the battlefield, he will not be Mirandized by the soldier, but yes, he will be Mirandized when he's brought to the interrogation process. Because if you're going to introduce classified evidence, classified information, into a domestic terror court proposal, you must absolutely be able to balance between the rights of the state and the rights of the individual. It is ultimately what I refer to as a hybrid proposal. It takes a little bit from this, it takes a little bit from that. It seeks to, on the one hand, enable the detainee, the defendant, to have almost full constitutional rights, even though he is not an American citizen. And here I rely on the words of Professor David Cole, who has compellingly argued that those who have been detained must be granted constitutional rights, even though they're not American citizens, because we have arrested them, we have detained them, and we are going to try them. But because there is, I suggest, a profound difference between the traditional criminal law paradigm and this terrorism paradigm, he will not have full constitutional rights. Do I think this is politically viable? Well, this is obviously the question that Charlie Savage's colleagues ask me all the time. Do I think that my proposal is politically viable post-January 20th? I think the answer is yes, because as I mentioned, we cannot close Guantanamo. Yes, we have to begin the process of trying them. Yes, we have to do so quickly, and yes, we have to be able to balance the multiple and complicated balancing issues that are at stake here. I suggest one other thing. I'm of those who believe that the next terrorist attack is only a matter of time, and so there will be additional thousands of detainees down the road. And if we do not implement a process, a constitutional-based process, and the word process is critical to the discussion, an institutionalized process, we will yet again have what I refer to as a panic response. Ambassador Prosper actually quoted me from my talk yesterday when I stated that we rushed off to Guantanamo. We rushed off to Guantanamo, and 7 years later, here we are stuck. So I suggest that in terms of moving forward, we need to take a deep breath and think, how will we respond the next time this happens? And the best time to start thinking about how will we respond the next time this happens is start thinking about it now. And that, by the way, I'm sorry that the Dean is not here. I think you all are to be congratulated for this conference, because the most important question of the day is, how do we go forward? How do we detain? How do we interrogate? And ultimately, how do we try? And the final word before I turn it over, we have a few minutes for questions. The primary or the principal purpose of a domestic terror court is to enable the trial of thousands of detainees who otherwise will not be tried, who otherwise will be in this forever black hole. We cannot morally, we cannot legally, as Americans, allow ourselves to continue this process. We must develop something else. We must re-articulate. We have no choice but to begin the process today. Thank you.